Well, welcome everyone, and thank you so much for being here. I'm Lior Samfiru, the employment lawyer, and you've come across my live stream session. Live stream, which means I'm live, you're live, and this is your employment law live stream session where you get to ask questions about your legal rights on the job with your boss, with your workplace. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm one of the founding partners of the firm. You can find us across Canada. And if you're in Canada, if you have a question about your legal rights, this is the time to ask that question. This is the time to get some answers and some help and support. This is such an important session because oftentimes people just don't know where to go to get real answers, to get real information, not something made up by AI or by some influencer on social media. Real information, real answers, real help, real advice. That's what this session is about. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And if you have a question about workplace rights, man, oh man, are you in the right place at the right time? If you want to know if your boss is allowed to do something, ask the question. If you want to know if your job is secure or not, if you want to know if your employer can let you go, if they can put you on a temporary layoff, how to deal with harassment, how to deal with discrimination or accommodation, all those things and much, much more, you can ask the question right now and get the answer from me live. Again, this is a live session. I see questions have come in. Thank you for that. I'm going to start answering them in a moment. I want all your questions. I want to be busy today. I want to be on my toes answering all the questions. And someone just said that they wish I was in NYC in New York. I wish I could help you. No, Canada, this is the place to get some answers. So let me give you some other contact information. To connect with me and my team off social media, off this live stream, man, it's really easy to do. All you do is go to employmentlawyer.ca. Address is over there, employmentlawyer.ca. Phone number is right there. You can call. Email address is there. You can send an email. You can fill out a form. And of course, while you're there, if you want to, you can also read and learn a lot more about employment law and workplace rights. But right now, I am live. I'm going to start answering some questions. And remember, there's no bad questions. You can't ask me a question that I'm going to think is bad or irrelevant. If it's a question that bothers you, it's important, and it's going to get an answer from me right here, right now, live. So ask your questions with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Enough of that. I say we start answering some questions. Ask yours too. First question today comes to us from YouTube, and that is from Andre. My employer told clients I was let go for misconduct, but I wasn't. Is that defamation? It can absolutely be defamation. Of course it can. They're just badmouthed you to someone in the public. They said something negative about you, that you're guilty of misconduct. If it's false, and it's easy defamation. It's exactly what defamation is about. No one is allowed to say or spread false information about you to others. It can hurt your reputation. It can hurt your career prospects. It can reduce your perception by people in the community. It is bad. So yes, we can actually help you with this defamation. But there's something else I want you to consider, Andre. If you were let go, you're going to be owed severance. So what are the chances that this employer actually paid you proper severance? I would say 0.03% of a likelihood that your employer paid you proper severance. So let's discuss that as well. Let's discuss the severance that you're owed so I can help you get that severance. But of course, defamation, clearly, no, not legal. We've done many of these defamation cases. We've resolved them. So reach out. So Andre, you can connect with me and my team. Very easy. Address is here, employmentlawyer.ca, the way to do so. Again, employmentlawyer.ca. Fantastic. Thank you for that question. I'm sorry you're in that situation, but as I said, there is help. By the way, if you're just joining us on this session for the first time, you don't know what this is all about, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and this is a live session where you get your questions about employment law and workplace rights answered. Questions have come in, I will answer them, but I want yours too. Watching, listening, learning, obviously that's really, really good. Even better if you ask your questions so that I can help you, and when I help you, I'll be helping others who may, of course, have the same issue as well. So ask the question. Just like our next person here, Kaylal has a question. Was offered a job. They said they were going to pay me for 45 hours a week, even though I'd only be working 40 hours. This is verbal and will not be put in writing. Is this stealing? And can this come back to me? No, it's not stealing if they're paying you, and that's fine. Now, the concern, of course, is, well, that they'll say that we didn't know you were only working 40. Somehow we only thought you were working 45. That's not going to happen. I'm not concerned. But here's what I would do. You don't need that in contract. Just send an email or even a text message. Say, hey, thank you, confirming that you'll pay me for 45 hours. Thank you for that. Then done. That's all you need. Something in writing to protect yourself completely. I wouldn't be concerned about it, but to have extra added layer of protection, email, text message, one line, as I said, protects you 100%. So that's what I would do here, and ask send that email. And of course, if you have any issues, problems, concerns, whatever the issue is, just reach out to me through employmentlawyer.ca. All right, great question. If you're just joining, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, here live with you right now, answering questions. Let's continue getting those done. By the way, just before I do that, I want you to always remember that legal rights can expire. Okay, so if you're sitting on the fence, should I ask questions? Should I pursue my legal rights? You may run out of time. Okay, you don't want to do that. Let's get the information, ask the question, understand what your options are, then you can make a decision. Too often people contact me when it's too late and I have to tell them, yes, you had legal rights. You could have been owed an extra $75,000, but it's too late now. Don't sit on your rights. Great place to start right here, right now on this session by asking me a question, getting the answer. Of course, I'm the employment lawyer, Lior Samfiru. All right, next question from Reddit, and this is from Fatima. I was given a promotion with no pay increase, but a lot more responsibility. Is that allowed? Well, the reality is that this is obviously an unfavorable thing for you. They're giving you more work, not more pay. So you could also ultimately say, no, I'm not doing this. Here's what could happen. If you say, I'm not doing this, one of two things will happen. Either they'll back off and either give you a raise or give you back your old job, right? Or they'll let you go. If they let you go, of course, they're going to have to pay severance. Now, why can't they let you go? They can let you go because an employer can let an employee go pretty much for any reason as long as severance is paid. So just like they could say, you know, we don't like the fact that you drive a blue car. We think you should be a green car, and we're going to let you go. That's dumb, right? No one's going to do that. But they could legally. They could also say, because you didn't like this promotion, we're going to let you go. So ultimately, you could either say, I'm not doing this, and they'll either back off or they'll let you go. It's as simple as that. By all means, if you want to connect with me, if there's issues, you can contact me, Fatima, through employmentlawyer.ca. And by the way, if they were to say to you, not too bad, we're keeping you in this promotion, etc., that could be a constructive dismissal. You can call me, we can discuss that, because your employer cannot just make significant changes to terms of employment. All right, great questions, by the way. I see a few more have come in. Fantastic. You guys are awesome. But keep them coming. I'm not done. You got time, right? Plenty of time to still ask your question. I will give you the answers. So I say let's continue. Afia, I think I'm pronouncing that correctly, has our next question. My manager has said that they won't be able to provide the accommodations I requested, and maybe I should resign. Wow. I have circulation issues and need to move regularly. What do I do? Okay, so the first thing is the request for accommodation shouldn't come from you. It should come from your doctor. So you telling them, hey, this is what I need, is not good enough. That doesn't necessarily trigger the obligation to provide that accommodation. Your doctor has to say that. Your doctor should give you a note, say for medical reasons. And by the way, your doctor doesn't even need to tell them what the medical reasons are. Just to say that for medical reasons, you need to have a job where you can move around. And I can guarantee you, your employer has to provide that accommodation. To allow you to move around is not a big issue. They have to provide that accommodation. If they still refuse, too bad, we're not doing that. Let me know, okay? Once they hear from me, all of a sudden, oh my gosh, of course we can accommodate. That was sorry, it was a misunderstanding. They'll accommodate. If they still refuse, that's a human rights violation. Potentially, you have all kinds of rights. Start with that doctor's note in writing. If they don't accommodate, let me deal with it. No problem. Things change very quickly as soon as they hear from me. Big misunderstanding. So that's what you do, Afia. To connect with me, employmentlawyer.ca, place you go to, phone number, email address, see right here, employmentlawyer.ca. Start with that doctor's note. And right now, if you have a follow-up question, ask it. I'm still here. You still have time. So if you have a follow-up question or a comment, do so right now. I'll get it and I'll respond to it. By the way, guys, you see the great questions I'm getting. You can ask your great question as well. Whatever the issue is, if it's employment law related, workplace rights related, this is the time, this is the place. I'm live on air with you right now answering those questions. Of course, me, who am I? Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And man, you guys are awesome. Questions are coming. I'm going to continue answering them. Carlos has our next question. My employer says my bonus is discretionary and won't pay it after termination. Do I still have a claim? So if you usually get bonus regularly, then, sometimes it's a bit more, sometimes it's less, but you usually get it, they have to pay it as part of your severance. And we would simply look at an average. So let's say we do a 2 or 3 year average. If your average bonus is, I don't know, $8,000 as an example, then that has to be accounted for as part of your severance. Your severance needs to include all components of compensation: salary, bonus, benefits, car allowance, stock options, pension, everything, okay? Bonus is a big component of it, so they have to include it. But Carlos, you're actually potentially putting the cart before the horse. And what I mean by that is, before we even talk about bonus and how and whether it should be included, we have to make sure that the other components of your severance are fine, that they're paying you for the right period of time. There's a 90% chance that whatever they're offering you, even if we forget about the bonus, is not even close to being adequate. So we got to deal with that whole thing. By the way, 90% chance, if you lost your job, whether it's last week, last year, tomorrow, there's a 90% chance that whatever you're offered, not even close to being the legally required amount. That's where you connect with me. Carlos, you can do that as well. employmentlawyer.ca, and I'll help you with the bonus and the rest of the severance package. So use that, check it out, and waiting to hear from you. Me, I'm Lior Samfiru, the employment lawyer. You'll reach my live stream session about employment law. Ask your question live, right here, right now. Next question from Ken O'Keefe. My employer emailed me that they need the med certificate completed and returned by the end of this week. I sent it by registered mail on Monday. Do I need to email them about this? Well, if you know it's on the way, you should email them and say, hey, here's information. You're going to get the certificate you asked for. No big deal, just so that they know it's happening. Yeah, it's a good idea to do that so they can anticipate it. Any issues, if they say it's too late, it's not too late, call me. employmentlawyer.ca has all the information that you need. All right. Fantastic. Thank you for that question. Let's continue. By the way, you can still ask your question. Plenty of time. employmentlawyer.ca, and right now, live stream, ask your question. There's a box on the screen. Type in the question, hit enter. It's going to come up on my screen, and I'll answer it. Let's see. LCJF5TP has our next question. My daughter was terminated today without cause. The letter says they trained her just to get cut. The letter says they trained her just to get cut. What can she do? So they're allowed to let her go without cause. That's the most common form of termination. And it may be completely unfair. It may even be unethical. But legally, they can do that as long as they pay proper severance. So the issue is not why they let her go. The issue is not how fast they let her go. It's a question of what is she owed, the severance that she's owed as a result of being let go. So I can help her make sure that she gets everything that she's owed. And even though she may have only worked for a short period of time, it's quite possible you'd be surprised by what she's owed. She could be owed several months' pay, not days, not weeks, several months' pay. So what do? Easy. Have your daughter reach out to me by phone or email. You and her can get all the contact information you need at employmentlawyer.ca, right down there, employmentlawyer.ca. She can call, she can email, we'll connect, we'll talk about how she was let go, how long she worked. We'll look at her employment agreement. I'll assess what she's owed. And if needed, I'll help her get what she's owed. Very, very simple. Thank you for reaching out. Next step is to have her reach out to me through employmentlawyer.ca. So thank you for that. Same with you at home. More questions have come in. We still have time, by the way. You might think, well, I'm not going to ask the question because I'll run out of time. You're not going to run out of time. If you ask a question right now, I promise you, you will get an answer from me live on this session before we end today. All right? Okay. By the way, I was just talking with LCJF5TP. I was talking about severance and the fact that just because her daughter worked for a short period of time doesn't mean she doesn't get a lot of severance. Well, how can you find out for yourself how much severance you're owed? It's very, very easy. I created a tool for that. It's been used by close to 3 million Canadians by now. It's called the Severance Calculator. That's it. And you can find that by going to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. That's one word, pocketemploymentlawyer.ca. And when you're there, you just click on the Severance Calculator. And the tool is going to be right in front of you. You answer a few questions, and it's going to tell you how much severance you are owed. Maybe you're owed 3 months severance. Maybe you're owed 12 months, 18, 24. Whatever the right amount is, it's going to assess that and give you that information so that you know. You'll probably be very, very surprised by just how much you are legally owed. Most people, when they use that, they think maybe there's a bug in the system, that it's not working properly. It's working perfectly, okay? Use it. It's completely free. It's completely anonymous. No names, no email addresses, no phone numbers, no company name. It's just for you to use anonymously. And if you want to, and only if you want to, you can even contact me directly from that severance calculator. Again, pocketemploymentlawyer.ca, address is down here, and check out the severance calculator. Fantastic. All right, let's see. Questions. That's what we want here. Let's continue answering some questions. Siobhan has our next question. I was let go and told I have to sign by the end of the month if I want the full severance package. If I don't sign, am I screwed for the full package? It's not enough time to speak to a lawyer. So that severance deadline is meaningless, okay? Your legal rights don't expire Friday at 5. Your legal rights don't expire for 2 years. All that deadline is a pressure tactic. Your employer is likely offering you a lot more. Take a step back. Your employer is likely offering you a lot less than what you're owed, and they're putting a deadline on it. Think how ridiculous that is. I'll give you an example. So, Siobhan, let's say I owe you $100. Let's say I owe you $100. And I say, tell you what, Siobhan, I'm going to pay you 30, but you have to accept by Friday or I'm going to pay you less. You would look at me like I'm crazy, right? Well, why would I accept 30 by Friday? Because you owe me $100. And you would be right, because that deadline is silly. It makes no sense. Well, that's what your employer is doing. They're offering you less than what you're owed, and they're giving you a deadline. Don't worry about it. You need to make sure that you get what you're owed. And I already gave you the tool to find out how much severance you're owed. You can go to the severance calculator, right? You can go to pocketemploymentlawyer.ca and use the severance calculator, and then call us to make an appointment, okay? Don't worry about that deadline. Your legal rights don't expire then. Your employer is sitting there hoping, man, I hope she accepts so that we can get away with it. Don't let that happen, okay? Please. You can go to pocketemploymentlawyer.ca to use the severance calculator. You can contact my office so we can schedule an appointment. You can do that through employmentlawyer.ca. So, Siobhan, I hope that makes sense. Any follow-up questions, you can ask it right now. But please, don't fall for that pressure tactic. That's all that it is. Okay, let's see. Next question. By the way, I'm Lior Samfiru. If you're just joining us, the employment lawyer with Samfiru, Tumarkin, LLP, here with you live at your service, answering your questions. You can ask it still. You still have time with the last 10, 11 minutes to get your question answered, so ask it. Sean has our next question. I'm from Canada. My friend is Indigenous Métis. got let go from a company, but the girl is a good worker. The company said they look at the first indigenous Métis. Not sure what you mean by that, but ultimately it's not a question of whether she was let go. It's a question of what she's owed as a result of being let go. I can help her assess what she's owed. All she needs to do is connect with me through employmentlawyer.ca. Again, employmentlawyer.ca, and I'll help her, whether it's to get severance, if she was let go because she's Métis, that could be a human rights violation. We can deal with that as well. Either way, I got to talk to her, right? She can reach me through employmentlawyer.ca, and I'll make sure her rights are protected, her rights are pursued. Let's not let anyone get away with something that's not legal, right? So, Sean, have her reach me through employmentlawyer.ca. All the contact information is right there. And you as well, if you're now joining us for the last 10 or so minutes, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And what I've been doing for the last 20 minutes or so, and I'm going to continue doing for the rest of the session, is answering your questions about employment law and workplace rights, and making sure that you're armed with the knowledge that you need to have if things don't always go well. Sometimes things don't go well in the workplace. There's issues, there's problems, there's dates, there's ultimatums, there's stress. What do you do? What do you say? What is legal? What is not legal? Great place to start right here live, asking that question and giving me the opportunity to help you. All right, let's see. Just like our next person here, Patrick has our question. And Patrick says, after 30 years of service, have been told that my job will be terminated this December. However, they mentioned jobs may be available at another warehouse they own, which is a 3-hour drive for me. The job would be a new job, not a transfer. So certainly that other job, not really relevant. It's 3 hours away. You're not going to accept it. So it's not a question of anything else other than severance. Unfortunately, they're allowed to let you go, but they have to pay you severance. After 30 years, even without knowing your age or the type of job, you're probably going to be owed right around 24 months of severance, 2 years of pay. Now, if they're giving you notice, so they're telling you in January that your job is going to end in December, so they're giving you, let's say, 12 or 11 months of notice. Those 11 months count towards your severance. So if you're owed 24 months severance and they give you 11 months notice, they have to pay the difference, 13 months in that example, by way of severance. So that's what they would owe you, okay? Now, it's in some cases, they may not be able to rely on the notice that they gave you, so they may have to pay you the full 24 months. So Patrick, given what's at stake for you, you got to reach out to me, man. You got to connect with me as soon as possible so we can assess your case properly. And you can do that by the address right here by going to employmentlawyer.ca. Again, employmentlawyer.ca. And we got to have that conversation, okay? So don't be bashful. Reach out. Let's do that. Thank you for that question, by the way. Great question. Let's see. Brandon, am I allowed to date my coworker? Do I have to tell my boss? Neither of us are in positions of authority. So the general answer is yes. Now, some employers have policies about this, but even if they do, they can't really stop you from dating someone, especially if neither of you is the other person's boss, okay? So not really anything that they can do about that. The only time you should tell them is if they have a policy in place that says, you got to tell us. And in that case, I would say yes. If they don't have that policy, you don't have to tell them. Words of advice, keep in mind, in some cases, if the relationship ends, there could be bad feelings by one side or another, and that could translate into the workplace. If that happens, you got to tell your employer at that point. Just you said, we broke up, it's been a bit ugly. It may be challenging to work together for a while, and your employer needs to know about that. But in terms of actually dating, yeah, there's nothing stopping you from dating, but look to see if your employer has a policy about that. Disclose it if they do. Ultimately, you can't be fired for cause for doing that. So you have that information, but always proceed with caution. I always say when it comes to dating in the workplace, you want to proceed with caution, because I have seen situations where those things turn very negative, and you want to avoid that impacting the workplace. All right. Great question, by the way. A very important question. And again, if you're now joining us for the last few minutes, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Anusha, you say a phone number. Well, I'll give you better. All the contact information is at employmentlawyer.ca. Phone numbers there, email addresses there. It's much easier to remember a website than a phone number. So if you want my number, my email, all the contact information, just go to employmentlawyer.ca. Fantastic. All right. Let's see if we can get a couple more questions in. You may still have time to kind of squeak in a question under the wire. So let's see. Next question is from Sam. My employer says my non-compete applies even though I was laid off. Is that enforceable? Well, I don't know anything about you, about your job, what kind of role you have, how long you've worked there, when did you sign this agreement, etc., when you were laid off. So I don't have any information to assess it. But here's what I'm going to tell you. You may not be actually asking the right question, because the right question may not be, is it enforceable or not? The right question may be, what happens if my employer tries to enforce it? Because it's quite possible that it's not enforceable, your non-compete, maybe even very likely. But if your employer tries to enforce it, they'll take legal action against you, and it'll be a very miserable experience. It could take years and cost you a lot of money. So that's the thing you should be concerned about, not whether or not it's actually enforceable. So my best advice is this. If we're concerned about your employer pursuing that non-compete, let me deal with it. I may be able to get them off your back, okay? And you say you were laid off. Maybe we also need to deal with your severance, because if you were let go, you could be owed many months' pay. So you got to connect with me. But always be careful with these non-competes, okay? Always be very, very careful, because they could be hugely problematic, hugely problematic. All right, by the way, last couple of minutes with me, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, and I love answering questions. This is what I do, and I'll try to get in as many as I can during this session. Next one is from Priya. My employer changed my job title and cut my pay, but says it's part of a restructuring. Do I have to accept this? No, you don't. Generally speaking, if your employer makes significant changes to terms of employment, that could be a constructive dismissal. What does that mean? It means you may be able to consider these changes to your pay and to your job as a termination of your employment and force your employer to pay you your full severance. So those may be the options. So you may not be able to physically stop your employer from making these changes, but you don't have to accept them. You could choose instead to consider it a termination. Very important though, not every change that your employer makes is a constructive dismissal. We need to assess whether what your employer did is or isn't a constructive dismissal. It very likely is, but I cannot say for sure until I know more about what did they change, how did your pay get affected, how long you've been working, what does your employment agreement says, if you have one. So what do we do next, Priya? You connect with me and we have that discussion. And of course, you can connect with me by going to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information you need is right there for you to use. And looking forward to hearing from you and everyone else. By the way, everyone that I've talked to today, that I've answered questions, please remember, just because I'm about to turn off here my webcam, doesn't mean I'm going anywhere. You can still connect with me. You can still ask questions. You can still get help. All you got to do is go to employmentlawyer.ca, use one of the means of connecting there, phone, email, forms. It's all there. So don't just wait until we're back here. This is the end of this session. We're about to end it. But again, myself, my team in Ontario, in BC, and Alberta, we're here for you. So please, please do the right thing. Connect with us and make sure you get help. Guys, I asked you to keep me busy today. You did. You asked lots of questions, lots of excellent questions. I'm happy I've been here to answer them. But again, I'm not going anywhere. Just go to employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer, with you today. We'll be back here again soon. Until then, take care of yourselves, and we'll talk. Take care. Bye.